The question is that the bill be now read a second time. The member for Hughes.
Thank you, Deputy Speaker. It's my great pleasure to rise this evening to speak on the Personal Property Securities Amendment, the PPS Leases Bill of 2017. What this does, Deputy Speaker, this fixes up a bill that was introduced back in 2009. I can remember, Deputy Speaker, back then reading some commentary when this bill was introduced by the former Rudd-Gillard-Rudd government and thinking to myself, how could the Parliament possibly legislate something that makes so little sense for the small business community? It was crystal clear to me at the time, Deputy Speaker, from sitting outside of this place, that what was actually in that bill back in 2009 would cause problems, would have unintended consequences, adverse and unfair effects. But, Deputy Speaker, at that time there was just so much poorly thought through legislation that this just piled another bad bill on top of another bad bill. However, Deputy Speaker, I have to admit that back in 2009, the Coalition, when they were in opposition, did not oppose the bill. So I have to be fair to, it was, I think, the then Attorney General, Robert McClellan. Yes, he was mistaken at many aspects in this bill. There were some good things originally in it, but I was a bit disappointed that the Coalition, Deputy Speaker, at that time didn't pick it up. But in their defence, there was so much confused and chaotic legislation being driven through the Parliament, often on ideological grounds, that I suppose that the opposition sometimes didn't know where to actually start. Now, where it was, Deputy Speaker, the concern that I had was over two issues. Firstly was what was known as the Ramalfa clause, or a retention of title clause. Now, what this enabled to do, this enabled a supplier, a wholesaler or a manufacturer, when they were on-selling goods through the supply chain, that they were able to have in their contract of sale a clause of a retention of title clause. And the clause was just simply something that I often put in the bottom of their invoice that said the supplier retains title to the good until they receive payment in full. Now, that was a fair enough term, Deputy Speaker. If a supplier is supplying goods on credit, it's fair enough if the person he is supplying to goes into insolvency or liquidation administrator is appointed, that he gets to retain title of the goods that he has supplied, especially in circumstances where he can easily identify what his goods are, they haven't been mixed with other goods, or they haven't been made fixtures in a particular property. And that worked well for decades. It was a contractual term that so if a company went into liquidation, the supplier could turn up, show the administrator or the liquidator the terms of the agreement they had, the supply agreement they had the retention of title clause in there, they were able to take their goods back. Simple, contractual terms, worked well, protected the interests of small business suppliers. But what happened by the change, Deputy Speaker, in this Act back in 2009? It said that simple contractual arrangement, no, Deputy Speaker, no. Now, what you have to do, you have to register your retention of title clause, and each particular sale you make, you have to register it with a government bureaucratic website, and you have to get it officially stamped. Otherwise, in a liquidation, what is your assets, what you should have retention to title to, or you thought you had retention title to, goes to the assets of the company in receivership, which in effect goes to the secure creditors and the liquidator, which was often the secure creditors, which are often the banks or the liquidator. So by those provisions, Deputy Speaker, you simply had an asset transfer from the small business community to help the big end of town, the large banks, Deputy Speaker, secured creditors who are able to effectively take possession, windfall possession of goods that they had no entitlement to whatsoever. The other concern, Deputy Speaker, with the original Act was in the rental and hire industry. Because what that made, Deputy Speaker, it made that if I'm a business hiring my goods to another company and I had an indeterminate term of the lease, and that sometimes may be the case, Deputy Speaker, because when you lease goods or a company hires goods, you don't know how long you may want that term for. You may want it for 3 months, 6 months, 12 months, a year, 2 years. So you had an undetermined time in the contract for the lease. If you had that, in an administration or liquidation situation, the goods that your company had hired out all of a sudden no longer became your property. Again, reversing years of simply common sense, reversing years of what was common practice in the industry. Now you had to take along your lease, get it stamped and registered at a government bureaucratic form, and if you didn't do that, you were at risk of the administrator taking ownership of your property. This was absurd, Deputy Speaker. Absolutely, completely absurd. And I see the member for Moreton's speaking on this bill, which is very good, because I had a look through, Deputy Speaker, how this legislation actually got through Parliament the first time, when it was so obvious, when it was... And I've said that, I've acknowledged that. I have acknowledged that. And I've wondered why. How did it get through Parliament the first time? Surely there were parliamentarians here that understood, Deputy Speaker, the damage that this would do. And it was interesting. And who was on the Speaker's list back in that bill in 2009? The member for Moreton. And he was telling us how wonderful it would be for solicitors, the legislation coming, how it would create more work for clerks. Well, I hope that when the member for Moreton makes his contribution to this bill, that he stands up and he apologises. That he apologises to this House for how mistaken he was back in 2009. And let's just have a look.
Order.
Let's just have a look at some of the damage that was done through the member for Moreton's legislation that he supported last time. A couple of cases, Deputy Speaker. And I hear the member for Moreton interjecting, and I have acknowledged, I was not here in 2009, and I acknowledged that the coalition did not oppose the legislation and voted for it, and I said that was wrong. So I would at least hope, I've been gracious enough to say that was incorrect, I would hope that the member for Moreton would stand up in this Parliament, admit that he made a terrible error back in 2009 and he got it hopelessly wrong. Now let's have a look at some of the effects. Let's have a look at some of the effects of what the member for Moreton's foolhardy support for that legislation did. A couple of cases, Deputy Speaker. The first one was a case of One Steel and all leasings. What happened, the leasing equipment in that case was in the value of $23 million. And what happened is that an all leasing employee responsible for making the government registrations failed to register the security interests, so he failed to do the bureaucratic government form in accordance with the specific registration requirements. In this instant, what he actually did, he used an incorrect ABN number on the registration. So what happened? That $23 million worth of assets was actually lost by the company and transferred to the company in receivership. A windfall gain, $23 million unfairly lost, all because of this original legislation. Another case, Deputy Speaker, was Power Rental Co. versus Forge Power Group, which was only only a month or so ago, Deputy Speaker. Now, what happened in that case? That was involving, of all things, 4 mobile wind turbines that were leased by the Forge Power Group from General Electric, and they were for a period of in excess of 12 months. But what happened, as GE was regularly engaged in the business of leasing goods, the turbines, they decided, even though you would think that you would have to bolt a wind turbine to the ground, the court held that they were not fixtures and found that the current leases under this PPS legislation supported by the member for Moreton over there, the turbines then became the property of the administrator. This was only after 1 month. 1 month had occurred that the leased goods were held by the company that was hiring them. They went in, they had struck financial difficulties. They had an administrator appointed, and it was $44 million US, probably close to $55 million Australian, Deputy Speaker, that was lost. An asset transfer from one company to another company, an unjust asset transfer, a complete windfall gain, and of course, Deputy Speaker, that money goes to the secured creditors, again, which would be the large banks, and also money to fund the liquidators' payments. Simply a transfer, Deputy Speaker, from often the small end of town to the big end of town under this legislation. So what this legislation does, Deputy Speaker, it does not fix the issue of the Ramalfa clause. And I would hope, Deputy Speaker, that very shortly, having fixed up this one mistake, that we would go back, and both sides of this parliament would go back and look at the issue of going back to simply the contractual terms of a Ramalfa clause, not having to be something that requires a government bureaucratic intervention, some government bureaucratic process that you have to go through to do it. Extra work, extra paperwork, extra processes, completely against the interests of small business, leading to unjust and unfair outcomes. So with this legislation, Deputy Speaker, what we're actually doing, the one thing we are doing on this, we're changing the minimum duration for which leases apply to be more from 1 year down from 2 years. So previously was 2 years, it's now 1 year. But more importantly, what it also does, that leases are of an indefinite term will not be deemed PPS leases unless they have run for a period of more than 2 years. So that enables companies, Deputy Speaker, to put on their lease documents that it's an indefinite period of time, and only once it gets over that 2 years do they need to register it. I'd prefer that there would be no need for registration whatsoever, but at least this remedies those appalling court cases that we saw, where their goods were simply little bit more than theft from one company to another. Now, Deputy Speaker, the member for Isaacs in his contribution talked also about what else the coalition is doing to get this economy underway. And the few minutes left, I'd like to address some of those things. Deputy Speaker, there's a couple of very important things that we need to do. Firstly, we need to get energy costs in this nation under control. And we cannot do that, Deputy Speaker, when coal-fired power stations in this nation are continuing to be run out of town because they can't compete with subsidised renewables, especially wind turbines. So as long as the Labor Party has the madness of supporting a 50% renewable energy target, there will be no investment in this nation in base-generated coal-fired power stations. That will drive up the cost of electricity, it will make electricity more unreliable, it will cost jobs, it will drive manufacturing offshore, it will make us a poorer and poorer nation. Secondly, Deputy Speaker, the other thing...
The member for Hughes will resume his seat.
Member for Hughes some latitude, but he should confine his remarks to the bill which is before the House. He's spoken at some length about the seriousness of these matters, and he should address them.
I listened to the member for Hughes. He was referring to the contribution from the member of Isaacs in this, and I admit that he is a little off the centre of the debate, but I believe he's still relevant. I call the member for Hughes. I'll give the member.
Thank you, Deputy Speaker. And look, that is correct. We have to allow broadness in this debate. And if the member for Isaac stands up and wants to bag the government, surely that we are allowed to respond. But we know what the other side think about free speech, Deputy Speaker. Just look at their...
Order.